Today I'm with Sue Prince, who is Professor of Law at Exeter University, or the University of Exeter. One of my favourite places to come, both the city and the university. Been to the city many times over the years on our way to North Devon and Cornwall. And my eldest son actually came to university here a few years ago. Sue and I have met several times. We were part of a small group of people who we called ourselves academics in dispute resolution. Was that right, Sue? Something like that. A collection of about 6 or 7 university professors and me, who was not one. And we've done some work together over the last few years, and I'm fortunate enough to have been invited a couple of times to do a guest lecture here at the university, which is where we are today. Terrible weather, but the sunshine is breaking through the window as we speak. And Sue, it's lovely to see you again.
Lovely to see you as well, Greg. And also Exeter was one of the few places in the country where the judges, following the introduction of the civil procedure rules, really got on board with mediation as part of a court-connected mediation scheme. And so we were sort of well known for Exeter being very passionate about mediation at a very early stage. Yeah.
And I think, thinking back, that's probably when we first met, because when I was at Cedar, I used to come to Exeter quite a lot to the court for sort of receptions and events and things, and you were probably at those events as well. But they're so long ago now, I think neither of us can actually remember.
There was a rota of mediation providers. I think we had, obviously Cedar on it, all of the big providers, but I think we were also fairly unique in having very forward-thinking judges who also included community mediators on that rota, so it wasn't only lawyer mediators. So interesting for me, because I was at the time evaluating that scheme, and I have sat in on so many mediations run by different people. Yeah.
Excellent. So do you want to tell me a little bit about your role here at the university?
I'm a professor, so that means that I teach, and I also focus on scholarship around education. I'm really passionate about public legal education, and also thinking about the future of legal education and the profession, technology, law tech, and especially sort of ADR. I think I got into ADR initially because of working on that court-based scheme here at the court, and also because of that interest that I've got in the future of institutions doing things differently, innovation, and so ADR attracted me when that very first came on board, because it was, I think, people who are more traditional lawyers were a bit worried about what it might introduce, and I think thinking about procedural justice and how we use different processes to achieve effective ends is very interesting.
Yeah, you're right. And part of the law that you teach here, obviously now you sort of concentrate on ADR as well, don't you, and bring mediation in particular into the course for your students.
So at the moment I am teaching elective module on ADR, but it's mainly mediation. In fact, I've been running this course. I think we were one of the first universities to run an undergraduate course in alternative dispute resolution. I started it in 2006, and it's been going pretty much off and on since then. I'm actually hoping to change. We just put in to change its name, so because ADR possibly isn't the right terminology anymore, so it's going to be called mediation and dispute resolution in the future, but essentially the same. And I think it's very interesting for me to see how that course has developed over time, and my interest in mediation, how things have changed. When I very first started that course in 2006, it's a half a course, and it still is, but I didn't have nearly as much content in 2006 as I have now. Now I'm trying to think about what I can leave out, whereas in those early days it was very different, and especially from a policy perspective, we were fairly soon after Halsey and just some of those developments. So, but yeah, things have really come on in leaps and bounds since then. And I've been also doing quite a lot of research into mediation as well. So it's taken me to a lot of places, which I've always been grateful for.
I was going to say, quite often when I see you pop up on LinkedIn, you're in Canada or somewhere like that, you do get to travel a bit, don't you, through your involvement in ADR. Is that ADR or is that the university? And
that's more, but it depends where I'm going, but mainly that's probably something else other than ADR. So, but I use the opportunities that I get. So I did get a grant from the Canadian government quite a long time ago to do some work on their mandatory mediation scheme in Ontario. And I do other work for the university now, but when I'm doing that other work abroad, I try and sort of pick up on where that jurisdiction is on mediation. And I also got a grant to do some work in New Orleans after Hurricane Katrina, and I worked out there with a very exciting group of mediators called Mediators Beyond Borders, and so that was really interesting at that time.
Yeah, I can bet. I know what you mean about the content now as well, and how sometimes it's like, I remember when I started the training at Hunt ADR, I thought, oh my God, I'm going to fill 40 hours. It's like, and this was only 5 or 6 years ago. How do I fill 40 hours? I was quite nervous about making sure we got everything in. Now we do the course and people quite often don't even get lunch breaks. It's like it could easily be 50 or 60 hours. And we go through the week and it's like, right, sorry, we've only got 10 minutes for lunch today. Go and grab something and come back. Because there's just so much content to get in, and constantly shifting it around to try and make sure that we get the right things in, but keep people's interest as well. Because obviously when you're delivering a training course, you need to keep it interesting so people are engaged. So yeah, there's so much information out there now that you could really you could probably do a 7 or 8 day course easily for the mediator training.
I think for mediator training, it is a bit different because there's a lot more focus on the how to do it, how to be a mediator, which I'm really grateful for you coming along to Exeter today, Greg, to do some of that work with our students. But a lot of the teaching that I'm doing is more about why
Right.
are we doing this?
Okay.
Because it comes as one element of a bigger course studying law, and so students are more focused on case law and the theory of law rather than the practicalities. So this is a real opportunity to think more about some of the issues that go alongside taking a case to court rather than the content of case law.
Yeah, which I suppose is an interesting dynamic for today, because one of the first things I'm going to be saying to them is I'm not a lawyer and I'm not particularly interested in the law, and yet I'm a mediator and I'm going to be talking today about mediation. So it's probably quite a shift from what they're used to.
Yes. I think most of the things that we do on this module are a shift, and that it is that challenge that is what I'm interested in. It's the challenging of traditional perspectives, and as you're talking about the training of mediators, I think they're more receptive by the time they get to paying for a training course. They're more receptive to learning how to be a mediator, what you need to do to mediate. But we've spent some time looking at the different styles of disputants and how people approach conflict. So we start from that point and then work our way up through a whole variety of different topics around the area of dispute resolution. And yes, those topics have developed, and clearly there's been more case law building up around satellite litigation, building up around mediation, which is really interesting from a policy perspective.
Yeah. Not all universities do what you're doing in terms of the ADR element. Why do you think it's important for the students and students in general to get that side of things? And also, do you think it's something that shouldn't just be available to law students? It may be more general business and commercial students would benefit as well.
Yeah, I agree. I think certainly now we are at a point in time where it seems clear from reading what judges are planning on doing in the civil justice field that there will be a lot more focus on settlement. So in terms of civil procedure, that focus on settlement is going to be really important, and how law students think about their own skills development away from knowledge of the law. And as we know, with the development around AI, that that whole field of knowledge and knowing the law is going to be different, but understanding how to use the law and thinking about conflict resolution in a different way is going to be really important. And when you are teaching law to undergraduate students, you have to think about where they're going, because they're not going to be lawyers, or they're not lawyers at the moment. They're not going to be lawyers in 1 year or 2 years. It could be, depending on what year they're in of their degree, it could be 3 or 4 years down the line before they go into practice, and the world will have changed by then.
Yeah. So how do you deal with that as a professor now? I know I've still got 2 children at uni, neither of them doing law, and I talk to them about AI, and I say, you've got to get to know what AI is. You've got to use it as much as you can use it. And then they say, well, we're not allowed to use it, we shouldn't use it. So it's sort of like, well, outside of your university, I want you to use it and learn it because it's there and it's going to be there. And I don't want you graduating in 2 years and not know what it is, because the workplace will expect you to know what it is now it works. But I appreciate that as part of your degree, you're not allowed to use it as much or at all. So how are you finding that sort of conflict between what you're teaching and getting the students not to rely on AI?
Yeah, I think there is a difference between using AI to write an answer, which is supposed to be in your own voice. And there's a difference between that and using AI to help answer questions where the information is out there anyway. So if you ask a question of generative AI and the question comes back and you understand how helpful that answer will be, and you're able to critique it, because as we know it's not totally reliable, then that is the skill you're developing. So it's not about just using generative AI, like feeding your essay question into generative AI and saying, oh, here, tutor, here's your answer, and hopefully we're not writing questions that you can do that so easily with. But if there is an exercise in which it's think about the questions that you're going to ask generative AI in order to get this answer, and then fact check those questions and critique the information that it's provided, that's the sort of thing that might be more helpful in the workplace. So it's how you use the tool in the same way as any of the tools that we're provided with that's going to be helpful. And that relates as well, I think, into our world, Greg, because thinking about public legal education, how people get to understand their rights, and how can we use generative AI to help people understand and use the law more effectively and give them more access. Once again, there's a danger there, because generative AI can hallucinate, but there may be, as we go through time and into the future, a way in which we can think about giving people more help and advice through those systems. So I think a lot of it is about training in the questions that you're going to ask generative AI rather than using it to pump for answers.
How do you think AI can benefit mediation?
That's a bit of a difficult one.
Yeah.
It's not. It's just. So I have seen some models whereby mediators are creating sort of chat bots to help people work through the sort of questions in mediation. I think training as well, there may be some help in that sense, I suppose. I think we could work through a sort of model of using generative AI to create resources for mediators, and then thinking about how we'd use them. I suppose the reason I say that's a difficult one is I feel we're still at a very early stage with mediation, and we don't really have any data. We don't really know what to feed into the generative AI to create
And that's
answers.
the key, isn't it? That is the key. As I've dabbled in AI, and sometimes I've been really impressed, and other times I've thought, oh my God, that's a terrible response. And then you find, as you refine what you actually are asking it for, that you get a much better response. And that's where the skill comes, I think.
Absolutely. And I think, some of the work that's going on in the justice system at the moment with the court service reform programme, and being able to flag maybe more data points in civil justice might help us have that understanding at some point in the future. But we're nowhere near that yet. We don't know very much at all, and the system itself is not helpful for us. No. But as we become better at knowing more about processes, but also understanding more about what makes, if I could ask you, Greg, I think one of the things I'm really interested in is what makes a successful mediation. You might answer me in one way, but other mediators might tell me something else, and other people might tell me something else. So if you're looking for technology to tell us answers to questions we haven't yet worked out the answers to ourselves, that's not going to happen.
No, I think it can be useful from the point of view of a mediator. It can be useful for doing some of the research that you maybe would do before the mediation. So if I think into the past, I've done, I remember one case, and it was to do with the manufacture of loyalty cards for a supermarket, and part of the dispute was the process. Now I could, asking the right prompts and the right questions, get quite a detailed analysis of what the process is behind that. So I'm a little bit more prepared, and I understand the language of it before I go into the mediation. Also, parties to the mediation. I was talking to someone for quite a large firm the other day who said, right, well, if I tell the computer that I'm having a meeting with Greg Hunt from Hunt ADR, it will prepare for me a sort of 3 or 4 page dossier on information about Greg Hunt from Hunt ADR, and it'll include who I am, where I've worked before, if any of the places I've worked have got anyone in that firm who has worked there, were they working with me at the same time I was working there, are they linked in with me, have I got any connections that are common to everyone, what the business has been doing. It might go to the company's house and look at the accounts, and it might find a load of information that I just wouldn't be able to find myself quickly, and it's there in a printed dossier in a matter of minutes. So you're much more prepared when you go to see somebody. And I can imagine as a mediator, that type of information might be quite useful to have about the parties.
It might be, it might not be right, I suppose.
Which is always the thing, yeah.
It's always the thing. So that you might know, if you take that information yourself, what you're looking for, and you'll be able to check whether it's useful or not. But I think you've got to be careful. And that's, I suppose, that idea that knowledge is so much more accessible than it ever was. But it's how we use it and how we ensure that the way in which we use it is going to be reliable. So that's what the skill, really, when you're using technology. Yeah.
It's interesting, and it's here to stay and develop, and it'll be interesting to see what happens over the next few years, because even in the last few months, just playing with it online, it's developed so much. It's almost unrecognisable from 6 months ago, I think, when ChatGPT first came out, and now the millions of different sort of search engines and tools you can use on AI now. I think one of the problems will be, well, which one do you use? Which one is the best one? Which one is the most accurate? Because there are so many different options out there.
And certainly, if you look at Lord Justice Burse, where he's been doing some work using AI to generate judgments, and I think that hits a lot of the legal press, the idea of robot judges. So it's coming at us from all over the place.
I certainly think switching code slightly to arbitration, there's a definite future for AI in arbitration, and being able to analyse the documents, particularly if you think of the arbitrations that we do, mainly documents only disputes, where we get a sort of a record of all the transactions that have happened through the complaints process, photographic evidence, video evidence, any supporting documentation, the contract, and then the other party will defend that and put their own evidence in and their own photos and videos and all the rest of it, and then the arbitrator analyses everything and comes out with an award. AI doing that is probably not a huge leap.
Makes you a bit redundant then, Greg.
Well, it won't make me redundant. It might make the arbitrators redundant. So if there's any arbitrators listening, don't worry, we're not there yet. But I think it's possible, definitely. And I know a number of arbitrators are significantly concerned about the impact it could have, that they are actually going down the route of trying to be one of the first arbitrators who takes this technology and actually uses it to their advantage to assist the parties. But yeah, I think in arbitration, because it's coming out with a decision rather than mediation where you're working with the parties live to try and get them into a position where they might want to settle. In arbitration, because you're coming up with a decision based on the documents that you're being provided, it lends itself more to having an output, which is a decision-based process from the AI. Interesting times. Will it put lecturers out of business?
Probably in the end of the day. I mean, things moving on I suppose it depends what you mean by a lecturer, but moving on to online technology and thinking about how we do the things we do, that's constantly evolving. So we are always developing, and you've got to be alive to that rather than thinking that you're immune. So I think technology will affect everybody's jobs. And if we're thinking about mediation, can the technology itself be the mediator? Rather than having, you obviously can have people as mediators, but there are processes which can be digitalised, and so that's one of the things that comes up in my course, is where we talk about online dispute resolution and the role of the technology itself as a neutral.
Yeah, which I've been looking at as well on Hunt ADR. One of the things I use at the moment, which has been a massive time saver for me, is when we do our mediator training, we provide participants with videos before the course to help them get some information in, and I actually now use AI and avatars to deliver those. And one of the reasons to do that is because if I was to sit there and do a video, so in the past it was me, so first of all I hate that, I hate doing it myself, I hate the fact I'm on camera, and I hate my voice on camera, and you're just going through it and whatever. But then if something changes, or you think, well, I don't really like that bit anymore and I want to put this bit in, you've basically got to reshoot the whole video or find someone who can edit. And if it was a year ago, might have had a bit more hair, a bit lighter, not quite as weighty. And, it looks different when you edit it. With these avatar ones, you just go in and you can add a new module, you can change a module, and it takes seconds. And it doesn't look any different. And then the software I use, the learning platform, just automatically updates. So if you've already got that video, you'll get a message to say this has now been updated, and it just goes on and keep going. So something where I first did a sort of half-hour on-demand course is now 2 hours long, because I'm just able to keep on adding modules and adding information, and it's so much easier than getting it videoed or sitting in front of your own laptop just boringly talking in and wanting people to listen.
And possibly good fun as well. So
good
fun to be a participant in that and think about what where that might be able to take you in the future. Yeah,
and because of the technology, you can add things in. So on that one, at the end of each module, before you can move on to the next module, there's a multiple choice question. 5 questions at the end of each module, and it marks them, and you have to get 80% right before you can move on to the next module. And again, that's not something I would have been able to do 5 years ago, just sitting in a room with me Zoom, recording myself, So I think even already just little things like that have made such a big difference. So that's really good. I know you had another couple of things you wanted to cover. Can you?
I suppose, I'm really interested in sort of what's happening at the moment in small claims, and particularly in terms of introducing a form of compulsory mediation, which is free to people. And I suppose I'm interested in seeing how that evolves, and whether or not that, by introducing more people to the concept of mediation, it makes a difference. But also the potential impact on mediators generally, in that once something becomes compulsory, that you have to think a little bit more about the due process elements and procedural justice, about what's fair and how it's legitimate.
And if it's free, who's paying the mediator? How?
Well, exactly. Who's paying the mediator, and is the mediator? All of those questions about quality and standards, and where mediation's evolved, and I've seen in my lifetime with mediation sort of growing up alongside its developments, the sort of introduction of the Civil Mediation Council and its role, the self-regulation. I look at other countries and see how regulation works there, and there's some interesting developments into the future. So I think that's another watch this space area in terms of what's currently happening in the world of mediation, because it is that thing where the butterfly stamp, something happens somewhere and it impacts on something that's going on elsewhere. So there's a lot happening at the moment in the world of mediation, as there always is. And it's interesting to keep an eye on that, and comparatively with what's happening in other legal jurisdictions as well.
I think it's interesting because as a mediator, I think, well, the lawyers will never be free, so why should the mediator be free? And there seems to be there's always seems to be a race to make mediation free or as low cost as possible. And I think, organisations like the Civil Mediation Council and others, Chartered Institute of Arbitrators, have been trying for some time to make mediation more of a profession in its own right. And if you want to increase standards and drive standards and make something of value, then there's got to be a cost associated with it. So it always worries me when it always comes up about mediation being free or low cost. And actually, I know a very successful mediator who used to charge the same as the highest paid lawyer in the mediation, because that individual was of an equal standing as that lawyer, and if they're getting paid that, why shouldn't they? And that was their attitude, and it worked very well for them, and they've been very successful. But certainly mediation, if you want a good mediator, it's not something to be done on the cheap. And if you want success.
And then we come back to, I suppose, those words of successful mediator and what people, and how what's the quality standard. If you want something to have a cost and a value to it, how do you ascertain that value when it's hard to determine what makes effectiveness? I suppose when people go in to see a lawyer, they may be, and this is obviously a vast generalisation, but if they're experienced, they would have a better idea of what a lawyer might be expected to do, potentially with a mediator. Because it's all confidential, it can be a little bit murky as to exactly what happens in a mediation. And I know, when I ask my students how many of them have seen a mediation, it's always very low numbers. But you sort of know what a lawyer does, and you sort of know when they're charging for what they do, what that is. Whereas, how do you rate success? And if it's by settlement percentages, then that's very hard to then say you're neutral. There's a lot of the work I think needs to be done, and research work that needs to be done in the area of mediation. And I suppose when I talk about these developments which are linked to court, then these are areas in which there are opportunities to create high standards in mediation. And to go back and then look at that training which we talk about. But once again, I think the career pathways for mediators can be a little bit opaque. How do my students are, well, how do you get to be a mediator? Do you have to be a lawyer first? Or can you just go, I love mediation, I'd love to be a mediator, how do you get to do it? Do you think it's possible for somebody graduating from university at 21 with a degree to become a mediator? Possibly they need some other experience.
I think it's more possible now than it's ever been, because I think the whole, and it's going back to AI, the whole sort of entrepreneurial set now, and it's taken it away from the law a bit maybe, but I think, normally what you say, well, parties want a mediator who's had some life, who's had experience and can sort of help that through the mediation to develop with the parties. But if you're a 23, 25-year-old entrepreneur who's, particularly in the tech fields, you might want someone a similar age to you who's also in the tech fields but has also got the qualification to be a mediator. So I think in certain aspects now, it may be easier for somebody young to enter the field, but certainly traditionally it hasn't been. And I remember looking at the CEDA mediation audit over the years, and looking at the average age of a mediator, a male mediator, And I first got accredited when I was 30. And I think at the time I was the youngest accredited mediator at the Chartered Institute of Arbitrators. And I was 30. And I remember looking, and the average age is 55. I'm not sure if it still is, but I'd be surprised if it's changed that much. And now I look, 23 years later, I'm 53. And technically, I'm still younger than the average age of the average mediator. And I think, well, there's got to be some scope for someone younger now, because I know through people I've trained now as a mediator that a lot of people who are in the early 30s, they're brilliant. They are so good, and they could easily go into a mediation and easily help the parties to settle that dispute. And it's so much more. I know I differ on many things with many people, and that's fine, because that's who I am. To me, 90% of being a successful mediator is about having the ability to communicate with people and to be able to have people relaxed with you and prepared to open up and prepared to move forward. And we spend a lot of that time doing that on the training, because I say, well, you can know all the process in the world. You can know the mediation, the 5 stages of mediation, inside out. You can know absolutely everything about the process, about case law, bring all the law in, bring in 80 years of business, commercial experience. But if you can't communicate with people, then you've not got a chance. And we concentrate a lot on letting our students learn and develop communication skills and interpersonal skills to be able to do that. And I get a sense that people who are leaving university these days, and this is only through personal experience and teaching some courses at universities as well, they're more ready for it now than they've ever been in the past. Yeah, I wouldn't have been at 21, but now I see students coming through and they've got much more better developed interpersonal skills. So yeah, I think the market is more open now than it was before. Very long-winded answer.
That's really exciting though, Greg. Really exciting.
Yeah. And I think it's good because it's showing that universities are putting out good students. And I think it's driven as well by the fact that this generation of students, so if I think of my eldest, who was here a few years ago, born sort of 2000, 2004, they've grown up with the technology. And, they know everything. And when we were kids, and we're like, oh, they know everything, and we didn't really, we just thought we did. These days, they do, because it's at the tip of a finger. And we'll be watching something on the telly, and I'll look over and Rob will be on his phone, and I'll think he's not even watching. And then when the programme's finished, he'll say, that bit when they said about this, I've just been researching it, and this happened really. And he'll give us a little history lesson about what happened in real life as opposed to what we've just seen on the television. And it's just there, it's at the fingers. And if you can combine that with teaching them to be able to communicate with people at all different levels, I think we've got some very powerful young people at the moment who can really make a difference.
I think entrepreneurship in mediation is a very interesting and exciting topic.
Mm-hmm. Yeah.
Perhaps for the future.
Yes, definitely. Something we should teach. Yeah. Someone's having a laugh down there. Okay, did you have anything else that you want to know? Well, it's been really interesting. Thanks, Sue. And thank you again for inviting me here today to speak to your students. And thank you for agreeing to be on this episode of No Dispute in That.
Thank you. Thanks very much, Greg.
Cheers. I'd just like to end this episode by remembering 2 people very close to me who died in the time between us recording the last episode and this. My big brother George, on his 61st birthday back in late October. Incredible man, miss him dearly. And then in January this year, 2024, after an illness with dementia, my mum also passed away. We miss them both. I'd like to end the episode by playing out with a little jingle that George wrote during lockdown for the business. Always brings a smile to my face and to all our family and friends who hear it, and I hope you enjoy it. Over to you, George.
You need a mediator, don't be late. Arbitrate to enhance your state. Adjudication is your road to salvation. Hunt ADI is your destination. He's working from home. Yeah, he's working from home. For dispute resolution, there's only one solution. Hunt ADI.